Kasuga,
Here.
Cervantes,
Here.
Rogers.
Here.
Thank you. Quorum's established.
All right. Welcome to the California Board of Psychology Legislative and Regulatory Affairs Committee meeting. At this time, I'd like to call on Mr. Polk to inform us about the CE credits for this committee meeting.
Thank you and good morning. Attending today's Legislative and Regulatory Affairs Committee meeting provides you with CPD hours under category number 1, attendance at a California Board of Psychology meeting. At the end of today's meeting, I will announce how many hours will be credited for attending the full meeting. Please note that the hours credited for attending today's meeting will also be applied to law and ethics. For attendees who joined by phone by calling the U.S. toll phone number and use the access code, please send an email to the following email address: bopce@dca.ca.gov. Again, the email address is bopce, as in Board of Psychology Continuing Education, @dca.ca.gov. In the email, please provide your name, license number, and the phone number of the phone you called in from. Attendees who signed in using a computer or mobile device from the WebEx link directly, please, your attendance is automatically documented and no further information is necessary as your name and email address was recorded upon joining the meeting. For any attendees who are in person with us today, the attendance sign-in sheet provided at the in-person location will be the board's record of your attendance. Please sign in and out as needed for today. For all attendees at today's meeting, please notate today's date as April 24th, 2026, and note that we are here for the Legislative and Regulatory Affairs Committee meeting. Please maintain this record, as this will be your record of attendance, as certificates of attendance will not be provided by the board. Again, at the end of the meeting today, I will announce how many hours will be credited for attending today's meeting. Thank you.
All right. Thank you, Mr. Polk. At this time, I just wanted to welcome everybody, including our board members that are part of the Legislative and Regulatory Affairs Committee, Dr. Shaconda Rogers and Dr. Maricela Cervantes, the board staff, as well as the participants that are in the 200s. Welcome. At this time, we're going to start our meeting like we usually do when Dr. Rogers is here, with a little mindfulness exercise. So take it away, Dr. Rogers.
So much. Excuse me. Thank you so much, Dr. Kasuga. It is a delight to be here with all of you, and it's always my joy and pleasure and honor to offer a mindfulness exercise at the start of our meetings. In the interest of time, I will offer a shorter mindfulness exercise so we can get into the work of the day. If you would like to participate, you are more than welcome. And if this does not feel supportive for you this morning, there is no need to engage. So do whatever feels right for you. If you would like to participate, I invite you to get into a position that is comfortable and supportive for this brief practice. Keeping the eyes open if that feels available and supportive for you. And if you would prefer to close the eyes or lower the gaze, feel free to do that in this moment. I will be lowering my gaze so I can also keep watch of the time. And for these next moments, let's bring the mind, the heart, and the body all into the same room. Many times our minds are wandering, processing information, thinking about things that may have occurred yesterday or things that are awaiting us on the other side of this meeting. But for this next moment or so, see if you can bring the mind into the present moment. Really allowing yourself to be fully present and here right now. Letting yourself rest for these next few moments of this practice. There are so many demands that are placed upon us, so many responsibilities, lots of asks, lots of tasks. But for now, we just rest. Noticing how it feels for the body to be supported by whatever it is we're sitting on. We're sitting on a chair, a bench, a sofa, sitting at a desk. Really letting your body come into contact with wherever you're sitting. So feeling your feet on the ground beneath you. Supported by the earth beneath the floor. And allowing the attention to rest on the breath. As it moves in and out of the body. Noticing the ways in which the chest and the belly rise and expand on the inhale. And then fall away on the exhale. And seeing if you can track the breath for maybe 1 or 2 cycles. Not doing anything to change or alter or modify the breath, but simply being with the breath as it moves through the body. And sometimes it's helpful to connect to the breath by placing a hand on the chest and or the belly. Just noticing the movement. And allowing yourself to be with the breath as it moves through the body. And as we're all gathered on this call today, centering ourselves, grounding ourselves, see if you can set your intention for being on this call. Perhaps it's to learn a little bit more about the work of the board. Perhaps it's to offer comments, to ask questions, to learn, to contribute, to advance the mission of consumer protection. Whatever it is, allow that to be your anchor that you keep coming back to if you find yourself drifting away. And as we begin to bring the practice to a close, just do a quick check-in to see where the mind is, the body is, and where the heart is. And allow this practice to stay with you as we move through the business of the day. And again, continue to return to your intention as you need to. Returning back to the stillness of the body and the movement of the breath. And as I bring the practice to a close, I will ring the bell 3 times. And you can gently bring your attention back into the room after doing so. Thank you, everyone, for your practice.
All right. Thank you so much, Dr. Rogers. Right now, we're going to move on to public comments for items that are not on the agenda. So the board may not discuss or take action on any matters raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. Before I invite speakers to come forward for public comment, I would ask individuals making comments to not discuss the specifics, including names, as to pending complaints, pending licensing applications, or pending disciplinary actions that may come before the board for a decision. This refers to current and pending complaints and possible future complaints. Such discussions are considered ex parte communications, as they could provide information to the members that is outside of the record, in violation of the Administrative Procedures Act. While there may be a desire to engage in further discussion with comments presented during this time, the board may not discuss or take action on any matter raised during this time. Although this may give the impression that we are not being responsive, these procedures are critical to ensure the compliance with the Open Meetings Act to avoid compromising the speaker's goals or the board's mission. In addition, if there is a speaker before you who expresses thoughts that are extremely similar to yours, please feel free to verbally agree with previous speakers instead of repeating the exact same comment. Each speaker will have 3 minutes. Ms. Moderator, can you please open the public comment?
Hi, this is the moderator. If you would like to make a comment on any agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are joined us today via mobile device, the hand icon may be behind 3 dots, other options. And if you are a call-in public member, you may press *3 to raise your hand. You'll have 3 minutes with a 30-second warning to make your comment. And we are displaying instructions, and we'll give you a moment. I do see a comment. Dr. Battle, you're going to be receiving an unmute request. Please click on that to make your comment.
Hi, good morning. Can you hear me?
Yes, we can. Please go ahead.
Hi, great. Okay. On February 23rd, 2026, the Legislative Affairs Office wrote a report on their recommendations for how the California Department of Corrections and Rehabilitations could increase their staffing and lower their vacancies, and then followed up on April 20th of 2026, the Federal Receiver over the Mental Health Program in CDCR, Colette Peters, proposed a similar sentiment to the Assembly Budget Subcommittee on Public Safety, and their proposal was to eliminate the requirement for licensed out-of-state providers to get California licenses. They believe that this would help with recruiting a wider pool of applicants, eliminate the need to increase psychologist salaries, and wanted to direct more CDCR staffing recruitments out of state, and by doing so, eliminating the need for staff to obtain California licensures. So my comment here is that I'm speaking today as a California licensed psychologist, a consumer, and a Consume California resident. I strongly oppose the proposal to waive California licensure requirements for out-of-state clinicians providing in-person or telehealth services within CDCR. The statutory mandate of this board is consumer protection, not solving CDCR's administrative staffing shortages, but waiving licensure effectively strips the board of its primary tool for that protection, which would be disciplinary oversight. If an out-of-state provider commits an ethical violation or harms one of our incarcerated patients, the board's ability to investigate and hold that provider accountable is severely compromised, which would also create a dangerous loophole. Patients may be harmed by clinicians unfamiliar with California-specific standards of care, legal mandates, or systems of coordination. This might include critical requirements such as duty to protect, mandated reporting laws, and also training on cultural competency and implicit bias. These are not optional. They are essential to the safe and effective care, especially for our complex and vulnerable CDCR patients. This proposal also has fiscal and workforce implications. It allows out-of-state providers to bypass California licensure fees, the CPLE, and other regulatory requirements, which potentially undercuts and disincentivizes California licensed psychologists. The solution to CDCR staffing shortages is not to lower the bar of care or bypass established protections, but to invest in recruitment, retention, and working conditions for our qualified California psychologists. This sets a very dangerous precedent and creates a slippery slope for all professionals that are licensed. So I urge the board to uphold its core mission and defend California's licensing standards. I ask that they reject any future proposals regarding eliminating the need for out-of-state clinicians and psychologists to obtain California licenses. Thank you.
Okay, thank you.
This is the moderator. Next, we have Paul Down. You'll have 2 minutes with a 30-second warning to make your comment. We are going to give you the unmute request. Please click on that to make your comment. Thank you.
Good morning. My name is Dr. Paul Down. I'm a licensed psychologist in the state of California. And in its simplest form, I want to second everything that Dr. Alana Battle had just stated.
Thank you. We have Joseph. You're going to be seeing an unmute request on your screen. Please click on that to make your comment.
Okay. Yes, this is regarding SB 934. I'm Dr. Joseph Nicolosi Jr., a licensed clinical psychologist and amicus brief contributor to the recent U.S. Supreme Court case Childs versus Salazar, in which the court voted 8-1 to uphold a therapist's free speech permitting change-allowing therapy, or what some have called conversion therapy. I represent the interests of many clients who come to me for help regarding early sexual abuse. Bill SB 934 puts a chilling effect for those therapists who work with clients who seek treatment for trauma regarding their unwanted sexual compulsions. This board should not support the bill in any way. I would like to briefly describe my previous experience with the Board of Psychology because it's a good example of why the board should not support this bill. The term conversion therapy is broad, vague, ill-defined. Sexual orientation is its goal. In contrast with this, the work I do is called reintegrative therapy. It uses evidence-based treatment approaches, the same approaches are found in other clinics to treat trauma. As a byproduct, not the goal, sexual attractions change, as now evidenced by multiple published peer-reviewed studies. This distinction is something that the board has failed to understand, and I faced harassment from a BOP representative because of this. I informed the Supreme Court justices of examples of how Agent N sent me inappropriate, this is Agent N, like Nicholas, Agent N sent me inappropriate and unprofessional requests, inquiring into information about my family, asking who I am related to, in addition to asking me about my online speech outside of therapy and whether I practice so-called conversion therapy. I presented this to the Supreme Court justices, and I think that's something that the board should look into, what Agent N sent to me.
Sorry, I just have to stop you for a second because this is an agenda item. So this is a comment section for items that are not on the agenda. We'll welcome you to have your public comment on the proper agenda item. Thank you.
Next up, we have Harold. Harold, you're going to be seeing an unmute request. Click on that to make your comment. Thank you. Harold, if you are speaking, we are unable to hear you. Please make a comment now.
Oh, yeah. Hi. So my name's Harold Beck. Thanks for listening to me. I thought the comment made on CDCR expanding the psychologists providing services was very insightful. I retired in August of 2022 after almost 22 years with CDCR. And all those points are very relevant. But I was always surprised that it's been so hard for CDCR to reach out for retired individuals like myself to do retired annuitant work. I've done other things since I retired, but I would have loved to be a retired annuitant working just for a few hours. And believe it or not, all these years I've not been contacted once, despite being on all the lists. So sorry, I'm a little congested. I have a cold this morning, but just wanted to share that with all of you. So very relevant comments. I think what CDCR needs to do is do outreach to retired individuals to really expand the base of people who can very easily provide services. Okay, thank you.
Thank you. I see no other comments. I return the floor back to you, Chair. Thank you.
Okay, thank you so much, Ms. Moderator. Okay, so now we're going to move on to agenda item number 4, discussion and possible action to approve the Legislative and Regulatory Affairs Committee meeting minutes from June 6th of 2025. To get started on this, do I have a motion?
So moved, Chair.
Okay, so there's a motion to approve the minutes from the June 6, 2025 meeting. Do I hear a second?
I second.
All right, it's been moved by Dr. Rogers and second by Dr. Cervantes. Do you have any comments from the board members, committee members? Do we have public comments?
Hi, this is a moderator. If you would like to make a comment on agenda item number 4, you may look for the raise hand icon at the bottom of your WebEx screen. If you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. I see no raised hands. I return the floor back to you, Chair.
All right, can we call the vote?
Kasuga,
Aye.
Cervantes,
Aye.
Rogers.
Aye.
Thank you. Motion passes.
All right. Moving on, we'll move on to agenda item number 5, legislation from the 2026 legislative session, discussion and possible action. Ms. Whitney?
Thank you, Dr. Kasuga. I will begin with item 5A. These are the 2-year bills on watch status, which can be found starting on page 18 of the materials. So there's the 3 bills, AB 277, AB 346, and AB 667. These bills were monitored in 2025 and they became 2-year bills. The board did not take any formal positions on these watch bills, and the board continues to watch them to assess any potential impacts on licensing, enforcement, and consumer protection. There has been no recent activity on these bills, and this item is for information purposes only, and no action is required at this time. Are there any committee comments or questions?
None from me.
Okay, thank you. Do you want me to jump right into the next item?
Yes, please.
Okay, so item 5B1, we have one bill that we have an active position on from the board. This is Senate Bill 903, which was introduced by Senator Stephen Padilla earlier in the year. This would establish new statutes to regulate how artificial intelligence may be used in therapy and psychotherapy services. It's intended to protect consumers by prohibiting unlicensed individuals or entities from offering therapy or psychotherapy services through artificial intelligence. For licensed professionals, the bill would require clear patient consent when AI is used to support recorded or transcribed therapy sessions, and would ensure that AI does not make independent therapeutic decisions or replace professional judgment. The bill also authorizes the Department of Consumer Affairs to investigate violations and impose civil penalties. The Board of Psychology met on February 13th and adopted a support position on this bill. Board staff prepared and submitted letters of support to the Senate Business Professions and Economic Development Committee and the Senate Privacy, Digital Technologies, and Consumer Protection Committee on March 13th. On April 7th, the bill was amended to include a variety of items, including removing the department's investigation and enforcement authority related to this bill, and place that authority with the appropriate healing arts boards. Also gives the boards explicit authority to develop regulations to implement the provisions of the bill. It defines a licensed professional as equivalent to the definition in Evidence Code Section 1010. It clarifies the definition of consent for the purposes of using AI in a supplementary support capacity and expands the definition of supplementary support. Prohibits an individual, corporation, or entity from using artificial intelligence to record or transcribe psychotherapeutic communications, psychotherapy sessions, or triage or screen patients unless the specified conditions are met, and would state that a patient does not surrender any rights to care if they or their representative do not consent to the use of AI. It expands and clarifies the prohibited uses of AI during psychotherapeutic sessions or when conducting screenings or triage. Establishes the responsibilities of a licensed professional when using AI for psychotherapeutic or triage/screening purposes when the use has not been selected, provided, directed, or mandated by their employer or contracting entity, and it establishes the responsibilities of a licensed professional and their employer or contracting entity when use of AI has been selected, provided, directed, or mandated by the employer or contracting entity. The board has thoroughly reviewed the amendments and felt the amendments clarified any remaining ambiguity in the bill's enforcement model. This item is for informational purposes only, and there is no action required at this time. Does the committee have any questions on this bill?
Any questions from the committee? I do have a clarifying question, Ms. Whitney, with regards to this bill. So this bill only talks about therapy and psychotherapy and does not include assessments. Is that correct?
I'm going to pass that over to Mr. Phillips in the enforcement unit.
Hello, Dr. Kasuga. So in regards to assessment, that was your question, correct?
Yes.
So the bill is still kind of in its early stages, and it hasn't been passed, and the language may or may not change if the bill does get passed. But currently, as written, no, a psychologist could not make assessments with AI.
As part of this bill.
Correct.
Okay, thank you.
You're welcome.
Right now, I'm going to open to public comments for both A and B, agenda item 5A and B.
Hi, this is a moderator. If you would like to make a comment, please click on the raise hand icon, typically at the bottom of your WebEx screen. And if you are on a mobile device, you can click on raise hand icon behind 3 dots, other options. If you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and will give you a moment. We have some raised hands. James, you're going to be seeing an unmute request. Please click on that to make your comment. Thank you.
Hi, this is Dr. Willis. I would like to suggest that the committee obtain legislative analysts' reports across several different departments that employ psychologists before adopting any position on this bill. I would also suggest that you reach out to Dr. Padilla's office, Senator Padilla's office, and find out which consultants or which industries also suggested language for this bill. I think that's very important to know where the basis for this and what the theories for this are being structured. I don't have any position at this point, but I think you need a lot of information before you establish ground rules for how psychologists are presented with using AI. In my own experience, AI is often operating before I'm aware of it. And I then discover it in my selection, like if I do a search, AI is operating and choosing what I see initially. If I turn on, if I download a document, suddenly Adobe pops up with its AI requiring me to sign in or making a number of suggestions that I read the summary as opposed to the document. So AI is pretty intrusive, and I think we ought to really get some hard evidence before taking any position. Thank you.
I see no other raised hands. I return the floor back to you, Chair.
All right.
We do have, we did this just last minute click.
No
John,
problem.
you're gonna be seeing an unmute request. Please click on that to make your comment.
Hi, this is Dr. Jean Chen Gorman. Can you hear me? Yes, okay. I don't have any particular suggestions. I just wanted to comment that I think this is an extremely important issue for the committee to prioritize. That we are right in the beginning stages of the use of AI across our daily lives. And there's great potential for this to be very detrimental to the field of psychology. So really wanted to ask the committee and the board to just prioritize this issue. Thank you.
Thank you.
Now we don't see any other comments. I return the floor back to you, Chair. Thank you.
All right. Thank you. Ms. Whitney, can we continue with agenda item 5C, please? Oh, we have like Dr. Rogers. Go ahead, Dr. Rogers.
I am so sorry that I did not pose this question before. I just looked down at my notes. I am not sure if anyone can speak to this in any detail or not, but I am curious from our enforcement unit if there have been any complaints that have come in that are related to AI. Without getting into any specifics, but have there been any issues that have been brought up to our attention?
Hey, Dr. Rogers, this is Daniel Phillips, the enforcement manager. Yeah, so there have been some instances of AI.
Okay.
Unfortunately, none of those are public cases, so I can't
Sure.
speak to any specifics on them, but
Okay.
we've received some in the past.
Okay, so some are coming our way. Okay, thank you so much.
You're welcome.
I know that this is a really important issue that we need to be monitoring, so was just curious if these kinds of concerns have crossed our desk yet. Thank you so much, Mr. Phillips.
I just want to add, I asked that same question when we discussed this bill last year. And at that time, if I'm not mistaken, there hadn't been any. So things are evolving. And I think that's just, I just wanted to accentuate that point.
That is correct. And also, I just wanted to echo that although we've already have a position for this bill, we are continuously monitoring it for any amendments. That way we can provide input if there are any amendments that we see fit or if we need to change positions. This is an evolving thing, so we're continuously monitoring it. Thank you.
Yeah, just one more point. I am pleased with these amendments because they do clarify our role and distinguish it from the Department of Consumer Affairs. So I'm pleased with that type of language.
I agree to the clarifying amendments are helpful. All right. We'll bring it back to Ms. Whitney for agenda item 5C.
Thank you, Dr. Kasuga. Item 5C1 begins on page 20 of the combined packet. And this is the first of our bills for committee discussion and possible action to recommend a position to the board. So 5C1 is Assembly Bill 2140, which was introduced February 18th, 2026 by Assembly Member Natasha Johnson. This bill increases the minimum fine for failure to report certain malpractice-related settlements, judgments, or arbitration awards involving licensed healthcare professionals who do not carry professional liability insurance. Specifically, it raises the minimum fine from $50 to $100 for licensees, claimants, or their counsel who fail to report qualifying claims within the required time frame to the appropriate licensing board. This bill maintains existing reporting thresholds and requirements, but strengthens enforcement by increasing penalties for noncompliance. The bill is relevant to the Board of Psychology enforcement and disciplinary functions as it increases the minimum fine for required reporting of malpractice claims and supports improved compliance with existing reporting obligations. Staff is recommending the committee make a recommendation of support to the full board at our May meeting. Any questions the committee may have?
All right. Any board comments or possible motions? Any discussion?
No discussion.
Would you like to move, Dr.
Yes.
Rogers?
Yes, I move that the committee adopt a support position.
So it's more like we are recommending to the board to adopt a support position. So moved?
Yes, so moved.
By Dr. Rogers.
And so seconded.
Okay. Any more committee discussion? Seeing none, let's move to public comments, please.
Hi, this is the moderator. If you would like to make a comment, please click on the WebEx raised hand icon at the bottom of your screen. And if you are on a mobile device, you may look for a hand icon behind the dot, 3-dot other options. And if you are a public member, you may press *3 to raise your hand. You'll have 2 minutes with a 30-second warning to make your comment. I do see a raised hand. Dr. Wallace, you're going to be seeing an unmute request. Please click on that to make your comment. Dr. Wallace, if you're speaking, we cannot hear you. You're still muted. We still cannot hear you. I'm going to send you another request to unmute yourself. Please click on that to make your comment. Gregory, are you able to unmute yourself?
Yes, I'm sorry. I have changed my mind. I apologize.
That's all right. Thank you.
Thank you.
I see no other raised hands. I return the floor back to you, Chair.
All right. Can we take the vote?
Kasuga?
Aye.
Cervantes?
Aye.
Rogers?
Aye.
Thank you. Motion passes.
All right. Moving on to agenda item 5C2.
Okay, so this agenda item is, again, one we're going to make a recommendation to the committee on. This begins on page 29 of the combined packet. This is Assembly Bill 2164 and was introduced by Assemblymember Rebecca Bauer Cahan. This bill extends California's protections for individuals engaged in legally protected.
Ms. Whitney, your voice got softer. Would you be able to kind of like speak louder or?
Yep, I'm moving closer to the microphone. Is that better?
Can you hear her? It's still a little bit faint.
Okay, is this any better?
It is for me.
Okay. So I'll just start this agenda item over, if that's okay. It begins on page 29 of the combined packet, and we're going to be speaking about Assembly Bill 2164, which was introduced by Assembly Member Rebecca Bauer Cahan. This bill expands California's protections for individuals engaged in legally protected healthcare activities, including reproductive and gender-affirming care. It extends existing safeguards to individuals who provided or supported these services while in another jurisdiction, so long as the conduct was lawful in that jurisdiction and would be protected in California. The bill was amended last week to remove the introduced version's new limitation that would have tied extradition permissibility to whether the acts would be punishable under California law. After the amendment, the bill prohibits recognition of certain out-of-state criminal liability tied to legally protected healthcare services. The bill is relevant to the board, licensees who may provide or support legally protected healthcare services across jurisdictions. So the staff is recommending that the committee make a recommendation of support to the board.
All right, thank you. Do we have a motion to recommend that the board take a support position on AB 2164?
So moved.
All right.
I second.
Moved by Dr. Cervantes, and we have a second by Dr. Rogers. And do we have any committee member comments? Seeing none, let's move to public comments on AB 2164 and the current motion.
If you like to, this is the moderator. If you would like to make a comment, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are a call-in public member, you may press *3 to raise your hand. You'll have 2 minutes with a 30-second warning to make your comment. We are displaying instructions and we'll give you a moment. I see no raised hands. I return the floor back to you, Chair.
All right, let's call the vote.
Kasuga?
Aye.
Cervantes?
Aye.
Rogers?
Aye.
Thank you, motion passes.
All right, moving along, let's go to C3, please. 5C3.
Okay, so agenda item 5C3 begins on page 39 of the combined packet. This is Assembly Bill 2575 that was introduced by Assemblymember Liz Ortega. This bill establishes new requirements governing the use of artificial intelligence and clinical decision support tools in patient care. It requires health facilities and providers to provide written notice of information about AI tools, including their development, limitations, and potential biases, and affirms that healthcare workers may override AI-generated output based on their professional judgment. This bill also prohibits employers from limiting clinical judgment or retaliating against workers for overriding or relying on AI tools, and clarifies that developers and users of AI cannot avoid liability by attributing harm to a provider's failure to override that technology. An amendment to the bill also provides parameters for disclosure or written notice. The bill is relevant to the Board of Psychology because it introduces new standards related to the use of artificial intelligence and clinical decision making, professional judgment, and potential liability considerations for licensees. The board may experience impacts on its enforcement workload, including the need to investigate complaints involving AI use and determine compliance with any new statutory or regulatory requirements. So the staff recommendation to the committee is that they make a recommendation of support to the board.
All right, any discussions? Questions from committee members or possible motion?
I move that we recommend support, a position of support to the board for AB 2575.
Thank you. It was moved by Dr. Cervantes.
I second.
All right. Ms. Whitney, I have a question with regards this bill, and would it have impact on our regulation with regards our informed consent, our regulatory language on informed consent?
That I'm not sure about. I know it does state that the bill specifically stated it has enforcement for licensed health facilities, licensed clinical or physicians. Licensed clinics or physicians that are subject to the jurisdiction of the Medical Board or Osteopathic Medical Board of California. It doesn't specify psychology. Would you guys want to possibly support, if amended, to include language specifically for the board?
This is something that I think needs clarification, because I am not sure how we'll be able to make sure that this is enforced with regards to our licensees without it being part of the informed consent. What are your thoughts? Do you have any?
I have a question. Is Sam Singh, our regulatory counsel, here? Because he should be able to. Could you help us with this question from Dr. Kasuga?
I would have to take a look at it, and I could give a better update, I believe, during the meeting, during the next board meeting. I'd have to take a deeper dive in it to see where we would stand with that.
Maybe we could table this discussion so that you can have your question answered, Dr. Kasuga. I'm just making a suggestion.
Yeah, I think that would be good, because two things here, like if we're not part of it, that's different from like knowing exactly what is being asked of our practitioners in terms of written consent and informing the consumers, the public, about how AI is being utilized within the practice. And I think part of it is like most of the bill is talking about the facility, so that would be a responsibility of the workplace, and that's not part of our jurisdiction. So I just wanted to make sure that it's clear for our practitioners what we're responsible for and what we are supporting in terms of this bill. Let's open up to the public in terms of public comments.
This is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen, and you can press *3 to raise your hand if you are a call-in public member. We are displaying instructions, and we'll give you a moment. I see no comments. I return the floor back to you, Chair.
Sorry, I was muted. All right. So, like, given that information and what Ms. Cervantes said. Do we need to withdraw the motion, or can
So
we get some?
you could go ahead and vote on the motion, and based on the fact that you'll be needing further information in order to be able to approve a suggestion to recommend support, you vote down the motion. If you decide at this point that's not the case, and then you could put forward another motion if you'd like to at that point to watch it for the time being, or bring it to the board meeting.
Why couldn't we just wait on, just table this and move on until Dr. Kasuga is satisfied that she has the response to the question?
I'm not sure I understand the question. Table it for this meeting, or are you saying just no decision made at this meeting and bring it to the board meeting?
I'm saying no. Dr. Kasuga, are you satisfied that you have enough information to cast a vote?
What I'm hearing is that like the recommendation is to vote down the current motion and then to watch it for now. Did I get that right?
Yes, if that's what the committee wants to do, that's definitely a position you can take.
Since we are looking for getting more information with regards to the bill, and we'll have, once we get more information, then we can discuss it maybe with a full board on our next board meeting.
Oh, okay, so we could, so I guess what I'm understanding is we could just vote down this motion, not take any position on this, and discuss it before the full board, where Mr. Singh can help provide additional information before the full board for their consideration at the meeting on May 15th.
Yes, that is correct.
Okay.
All right. Are we ready to take the vote?
Yes.
Okay. Ms. Whitney?
Okay. Kasuga?
No.
Cervantes?
No.
Rogers?
No.
Motion does not pass.
Okay, we'll continue to watch this bill, and we'll take it up on our next, on the full board meeting with more information. Thank you so much. Okay, we'll move on to agenda item 5C4.
Thank you. So agenda item 5C4 begins on page 52 of the combined packet. This is Senate Bill 1391 and was introduced by Senator Aisha Wahab. This bill requires boards, bureaus, and commissions within the Department of Consumer Affairs that offer a retired category of licensure to disclose that information on the internet websites. While existing law authorizes boards to establish retired license categories by regulation, this bill adds a transparency requirement to ensure that information about such licensure options is publicly accessible. The Board of Psychology currently maintains information on its website to ensure compliance with disclosure requirements, including notice of the availability of a retired license category. Board staff are recommending that the committee make a recommendation of support to this board, or to the board in May.
All right, thank you. Is there any comment, question, or a motion on SB 1391?
I move to recommend a position of support for SB 1391.
I second that.
Thank you. It's been moved by Dr. Cervantes and seconded by Dr. Rogers. Any additional comments from the board? Committee members? Seeing none, let's move on to public comments.
Hi, this is the
For the
moderator. If you would like to make a comment, please look for the raise hand icon at the bottom of your WebEx screen. And if you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you. Oh, we do have it. Oh, we do.
Okay.
There's this last minute comment. Dr. Willis, you're gonna click on unmute yourself to make your comment.
This is Dr. Willis. I'd just like to thank you for supporting this motion. I think this is a good idea. I'm one of those people who's going back and forth about when I'm going to retire and if I'm going to retire, and offering me that assistance would be helpful. Thank you very much.
Thank you. I just wanted to inform the public that we're already doing this since January 2023, and that's one of the reasons why we are in full support of this bill.
I see no other raised hands. I return the floor back to you.
All right. Ms. Whitney, can you please call the vote?
Kasuga,
Aye.
Cervantes,
Hi.
Rogers.
Aye.
Thank you. Motion passes.
All right. Moving on to agenda item 5C5. Ms. Whitney?
Thank you. This is the last of this particular item. So agenda item 5C5 begins on page 60 of the combined packet. This is Assembly Bill 1558, which was introduced by Assemblymember Joaquin Arambula. AB 1558 would enact the Uniform Emergency Volunteer Health Practitioners Act that authorizes the establishment of additional volunteer registration systems to support emergency response efforts. This bill allows licensed health practitioners from other states who are registered through approved systems to provide health or veterinarian services to California during a declared emergency, subject to oversight by the Emergency Medical Services Authority, also known as EMSA. It also establishes standards for scope of practice, credential verification, administrative discipline authority for licensing boards, and workers' compensation coverage for volunteer practitioners for responding to emergencies. This bill is relevant to the Board of Psychology because it authorizes out-of-state health practitioners to provide services in California during declared emergencies and allows the board to impose administrative sanctions for conduct occurring during emergency response activities. This bill may impact the board's licensing and enforcement oversight of out-of-state practitioners, as well as its disciplinary authority during declared emergency conditions. The board staff is recommending the committee make a recommendation of support if amended, and would like the amendment to clarify whether EMSA and or licensees and registrants regulated by a board are required to apply for out-of-state temporary practice or notify the board when practicing out-of-state as a volunteer declared or during a declared emergency. Does the board have any questions on this? Or I'm sorry, the committee?
Yes, thank you, Ms. Whitney. I think one of my questions too is what would be the time frame for the emergency license or practice? Would it be until the conclusion of until the emergency is lifted? Because that could be, very extended period of time, and I'm just like wondering what types of emergencies is anticipated to fall under this. Like, if you can provide some examples.
So it's still fairly vague on examples and timelines. There are other states that have adopted versions of this to kind of facilitate cross-state practice during declared emergencies. Colorado, Illinois, Indiana, and a few others. And the only other thing we're not sure about is, how the board is going to receive the notification. The intent of the bill is good, but that's where we need to amend it to fit the needs of our board. An example could be of like the LA fires when we had a lot of psychologists that were licensed in LA County, and either their home or their practice burned, or they were affected by the fires and could not maybe provide mental health services to those in need. So there had been a shortage during that time. And so this could be a situation where one of those, a declared emergency, where we could use the resources available through the system of registered. The licensees do have to be in good standing with their licensing board. That is one of the provisions in the bill. Does that help answer some of your questions? I know you probably still have some more.
Well, thank you, Ms. Whitney. It's good to have at least one example of, I can see how it could be helpful with regards to the fires, and that may be a more time limited type of emergency. I'm thinking about like if there's another pandemic wherein it could be like 3 years where we have this authority, and then we have like gonna have an influx of individuals providing therapy in California through this bill, and that might really pose a lot of additional workload for board staff.
Would you?
I understood. I'm sorry. I just have a question to what Ms. Whitney, the example that Ms. Whitney used. What I was, and maybe I'm just not understanding the situation. What I understood about the premise for this bill is when there is a declared emergency and then suddenly people from health providers from out of state come into an area to deal with the emergency, I understood it as an emergency response, like a temporary response. I don't know, a month, however long. Not as a replacement of the workforce that would normally be working in that area. Am I misunderstanding?
No, that's correct. It would be for declared emergencies, but that's where it's just not clear in the bill on the time limit. I don't know.
I get
like, for example, the executive order on the fires, that was for a certain amount of time. I think it was like a 6-month time frame with that executive order. So I think it would depend on how the emergency is declared and what it is and what the parameters of that particular emergency are. But it's not that the timelines are not defined in the bill.
I understand now. Thank you. I move to recommend a position of support if amended to clarify and ensure that the recommendation here on the processes we already have for temporary practice are upheld.
We have a motion by Dr. Cervantes.
I
and a
second that.
by Dr. Rogers. So it's a motion for to recommend a support if amended position to the entire board. with information with regards the need for notification and specific timelines. Do we have any more committee discussion or comments? Seeing none, let's bring it to the public, please. Let's take public comments on the motion before us.
This is a moderator. If you would like to make a comment, please click on raise hand icon at the bottom of your WebEx screen. We are displaying instructions, and we do see we do see a couple of comments. Dr. Elena, you're going to be the first one. Please click on the unmute request and make your comment.
Hi, this is Dr. Alana Battle again. Similar to the comments I made earlier about CDCR, I raised similar concerns about allowing out-of-state practitioners to practice in California. We already have provisions that allow temporary practices within California. So I just wanted to clarify when the committee said that they moved to support it. I was wondering, but you had made some comments saying that you wanted to ensure that it had designated timelines and some information regarding that. Can you clarify if that meant that you support the bill regardless, or those changes would have to take place in order for the board to support them? Just wanted clarification.
Thank you.
The recommendation we have from the staff requesting the amendment is to clarify whether EMSA and/or licensees and registrants regulated by the board are required to apply for out-of-state temporary practice or notify the board when practicing out-of-state as a volunteer during a declared emergency. So that's the clarification that the staff is recommending, and the motion is to support if amended.
Thank you. And this is the moderator. The next comment is from Maxine. Maxine, you're going to be receiving an unmute request. Please click on that to make your comment. If you are speaking, you are still muted. We still cannot hear you. If you are, now we can.
Okay, thank you. My name is Dr. Maxine Gann. I'm wondering how would you verify whether someone is in good standing who might come in out of state to provide services during an emergency such as you've been discussing?
Next comment is from John Roberts. You're going to be seeing unmute request. Please click on that to make your comment.
I hope I'm coming through.
Yes, please go ahead.
Okay, thank you. Two questions. One question and one comment. I'm a little confused about whether this bill pertains to California psychologists working outside of state during a declared emergency, or a declared emergency within California where we're bringing in people to supplement I don't know how many psychologists we have in the state, but quite a few. Can somebody clarify that for me, please?
Thank you.
The next question, would you like me to take the next comment?
Ms. Whitney, do you want to?
We have two more comments.
Okay.
This is the moderator.
Okay, we'll just have we'll listen to all the public comments and then we'll respond afterwards. Thank you.
Okay, got it. Patricia, you're next. If you are on a mobile device, you can click on did you see the unmute request? Please click on that to make your comment.
Patricia O'Neill, PhD, clinical psychologist. I want to encourage the board to amend their recommendation to say something like, if there's an emergency declared inside California, that requires us to allow outside people to provide help for people in need, but it should be amended to say continued until the state of emergency is lifted. I fail to see how doing it any other way would be useful. If there's an emergency, there's an emergency. Thank you.
Next, Andrea. Andrea, you're gonna see the unmute request. Please click on that to make your comment.
Thank you to the committee for taking up all of these very important issues. I'm Dr. Andrea Davis, clinical psychologist. I just wanted to share just personally that emergency provisions in another state I was able to utilize, whereas a temporary license was very difficult, but an emergency license for a client who needed some support in another state were extremely useful for the client and for me as a California psychologist. This was the state of Indiana. It was very straightforward. There were some provisions, but it definitely referred back to the Board of Psychology in my state and made sure that I was properly qualified to help in a state of emergency during COVID. So I just wanted to say I think this is important to allow, and I agree with the prior comment that it should be clear that it's only during the state of emergency. Thank you.
Next up, we have Dr. David. You're gonna see an unmute request. Please click on that to make your comment.
Okay. Good morning. Can you hear me? Yes?
Yes,
Thank
I
you.
hear you.
My question really goes to liability. If we have people coming into the state, especially volunteers, if that person or persons fall below the standard of care, especially volunteers, where does liability fall while protecting the general public? And how do we then enforce liability? Well, it goes to liability for the person coming in and then falling below our own standards of care. And then they go back to their home state. And potential litigation in that regard by the consumer.
Thank you. Next up is John Roberts. You're gonna be seeing an unmute request. Please click on that to make your comment.
I've done some work with disaster response, and I've done some work with critical incidents. And I've got a bunch of friends that are in the field who have traveled to other parts of the world to help out. And when it's a disaster, it's usually defined, the rotations are usually limited, like for a week or a couple of weeks, where people are actually going to another area. It's the idea of a disaster response, which is a very acute period of time. I found that emergency declarations, as you have already indicated, Dr. Kasega, can be anywhere between like a couple of weeks to 3 or 4 years. And that just having this defined by the length of emergency response doesn't really give you the focus on an acute disaster response that would be a relatively short period of time. And the declarations of emergencies can be a pretty long period of time and may actually create a lot more of a problem around being able to transition care to people as they become available or people become accessible. I would see this as something that would appeal very much to a disaster response protocol, as opposed to
30 seconds.
As opposed to something like an epidemic or something more long-term, like a period of unrest? Thank you.
Thank you. This is a moderator. I don't see any other requests. I return the floor back to you, Chair.
All right. I'll try to answer a few of them, and then I will pass it on to Ms. Whitney and maybe Mr. Phillips for some of the questions that were posed. So basically, this bill is relevant to emergency authorization in California emergencies. And as part of the current motion, we are in support of the bills allowing emergency practice during a declared state of emergency, but we need to know two things. One would be whether what is the notification with regards the board for people that are going to be practicing without a license in California, as well as the time limit, because it's not clear on the bill. So we would need a defined time limit. So that is the current motion that is in front of the committee. I would have Ms. Whitney add more a clarification, and maybe Mr. Phillips with regards to questions on enforcement.
Thank you, Dr. Kasuga. So as far as Dr. Roberts, you had asked whether it was for licensees in or out of California. It's for those that are not licensed in California to be able to provide services during a declared emergency to California residents. And the bill does not, to answer Dr. Gann's question about how to verify good standing, it does not specifically state how they would do that, but that is a requirement for them to be in the system. I don't know if there's an approval of some sort for the system. The bill does not state any of that at this point. And then I'm not sure if the committee would like to address the additional language of lifting, or that I know we're addressing the time limits, but I don't know if you want to specifically put the language about the state of emergency is lifted is when that would end. You guys have thoughts on that one? If you want to amend or if you just want to get clarification on the timelines in our amendment, would that suffice and answer your questions on those?
I want to answer the question on the time of the duration of the declaration of emergency. I don't know that that's practical. We did that with several regulatory changes during the pandemic, and at some point it just became impractical. We were now starting to see, as things were coming back from the pandemic, we were starting to have kind of some inconsistencies that I think we were kind of in there was just a lot of different dynamics happening, and because we had attached our change to the declaration, it just wasn't as clean as I think I would prefer if we had more flexibility on that. That's just my preference. Otherwise, I'm satisfied with the staff recommendation to support if amended.
Dr. Rogers, do you have any thoughts on?
I do just have one question related to Dr. Gann's comment about verifying good standing. Would that fall under the purview of EMSA, or would that fall to the board to determine? Or perhaps it's not very clear.
It's not super clear.
Okay.
My initial thought would be it would be the EMSA, because they'll be required to notify the board, because if we're, and I'm reaching for that, if I'm thinking if we're in an emergency, we're not going to go in and approve. We wouldn't go in and verify the good standing if they're already in the system.
Sure.
That would be a different services, I would assume. Does that answer
Yes.
your question?
Thank you.
In a way, I'm actually I like that we don't have to do the verification. It's gonna be less work for board staff. But in terms of Dr. Cervantes's comments, I would prefer if the board would have the authority to end it, you know, like if instead of like having it attached to, you know, the end of the emergency, the state of emergency declaration, if it's like if there's a way that we can be flexible in terms of what we see as the need. So I think more clarification on that would be good in terms of the time limit. Mr. Phillips, do you have any comments or clarification with regards to enforcement?
None at this time. It would be very fluid. I don't have any comments or clarifications at this time.
Okay. All right. Any other committee member comments or questions with regards to the current motion? Seeing none, let's call for the vote.
Kasuga?
Aye.
Cervantes?
Aye.
Rogers?
Aye.
Thank you. Motion passes.
All right, that concludes agenda item number 5. At this point, I think it will be a good idea to have a break, a short break, before going into the next item. Would that be, what's the requirement? Is it 15 minutes or 10?
It's a 15.
15, okay. So we'll have a 15-minute break. It's 10:36 a.m. So I will have Ms. Whitney call the roll again.
Kasuga?
Here.
Cervantes?
Here.
Rogers?
Here.
Thank you. Quorum's established.
My clocks are all different, so I apologize if we are back in session quickly. So right now I'll have Ms. Whitney introduce items on agenda item number 6, and we will do it out of order. These are watch bills, but there might be one that we wanted to discuss further, and then afterwards I will be asking about sorry, I'm getting ahead of myself. So let's do agenda item number 6 first, which is legislative items for future meeting. The committee may discuss other items of legislation in sufficient detail to determine whether such items should be on a future committee or board meeting agenda, and or whether to hold a special meeting of the committee or board to discuss such items pursuant to Government Code Section 11125.4. So is there any items for future meeting that the committee members wanted to bring up?
I think we've gone a little bit out of order. I think we'll go with item 5D first.
Oh, okay. Sorry.
Yeah.
Okay, let's do 5D first. Okay, let's go back. This like breaks, like, throws me off. Someone says like, yeah, so, okay, let's go back to Ms. Whitney presenting item 5D1, 5D4. We'll take it out of order in terms of the watch bills. So we're on the watch bills. We're still on agenda item 5D. Okay.
Okay, thanks, Dr. Kasuga. So this item is going to be item 5D. There's bills 1 through 7, and these are bills for committee discussion and possible recommendation to the board as watch status. As Dr. Kasuga discussed, I'm jumping a little bit out of order, and we're going to discuss 5D4, Senate Bill 934 first. This item can be found on page 110 of the materials. And so this Senate Bill 934 was introduced by Senator Scott Wiener. The bill expresses the legislature's intent to enact legislation that would provide individuals harmed by sexual orientation or gender identity change efforts performed by licensed mental health providers with additional time to seek civil remedies for those harms. Under existing law, engaging in sexual orientation change efforts with a patient under 18 years of age is considered unprofessional conduct and subject to disciplinary action by the provider's licensing board. The board is monitoring this bill because it relates directly to sexual orientation change efforts by licensed mental health providers, which are regulated as unprofessional conduct and fall within the board's disciplinary authority. I would like to note that the board did receive one written public comment on this item, which can be found on page 23 of the hand carry packet. Does the committee have any questions?
Thank you, Ms. Whitney. I am interested in this particular bill because of the consumer impact that it has, and I am in support of providing consumers of psychological services with the ability to take action for recovery or damages for harm that they've experienced. So I think that as part of our consumer protection hat, I want to move that we recommend to the board a support position on SB 934. Is there a second?
I'll second that.
All right, it's been moved by Dr. Kasuga, and we have a second by Dr. Cervantes, and we can have committee discussion.
Just sort of have a procedural question regarding the recommendation to the board to adopt a position versus continuing to watch it. Could someone just provide a little bit of clarification around when we move from watching to taking a position, whether it's support, oppose, support if amended?
A position can be taken if a recommended position can be taken by the committee to bring it to the board. And then ultimately the board could either accept that recommendation from the committee, or they could choose not to accept that recommendation, but the recommendation from the committee can be made to support versus watch.
Understood. Thank you.
Any other questions or comments with regards the bill or the motion? All right, seeing none, let's move to public comments on SB 934. I would just like to remind the public that not to discuss any specific cases with regards this bill, and the comments are only with regards to the motion in front of us, which is recommendation to the full board to support SB 934.
Hi, this is the moderator. If you would like to make the comment, please click on the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you can press *3 to raise your hand. You will have 2 minutes with a 30-second warning to make your comment. We do see a couple of raised hands. IFTCC representative, you're up first. I'm gonna send you the unmute request. Please click on that to make your comment. Thank you.
I also just wanted to add that if there are specific cases that are raised, despite the caution that we are reminding everybody, we will mute the commenters. So please keep that in mind. Thank you.
IFTC representative, if you want to make your comment, please go ahead now.
Thank you for the opportunity to share comment in opposition to SB 934. I represent the International Foundation for Therapeutic and Counseling Choice. We serve mental health professionals in California and over 30 nations. The American Psychological Association's Handbook of Sexuality and Psychology says same-sex attraction may develop from psychoanalytic factors, not biological, and it commonly changes in men and women, adolescents, and adults. A consensus statement by endocrine societies around the world says there is no consistent evidence that the brains of gender dysphoric people are different from the brains of people who identify with their sex. They said gender dysphoria develops from a mixture of psychological, social, and biological influences. Studies that have found that gender dysphoria commonly resolves for children and adolescents. Same-sex attraction and behavior may decrease significantly through safe, consensual counseling conversations. All the existing gold standard research of which we are aware, randomized controlled trials, across ideologies of the researchers, have found safe mental health interventions may decrease same-sex attraction in partners and increase opposite-sex attraction. All the longitudinal studies of which we are aware support these findings. These kinds of studies, even if not perfect, are recognized as far superior to the cross-sectional surveys by which researchers generally have acknowledged they did not prove change counseling caused harm and then asserted it anyway to professional organizations. Contrary to conventional wisdom, most same-sex attracted people by far are both sex attracted according to the APA's handbook and rigorous research, and the vast majority choose opposite sex partners and may have children. Nearly a third to half of men who change counseling
20 seconds.
are married to opposite spouses and sex spouses and are fathers. This counseling is especially effective for them. Their right to this help to protect their marriage and family they love should continue. Some gender dysphoric people and adolescents may need this help for their relationships also. SB 934 would take away this much needed help. We urge you, do not support SB 934. Thank you.
Elizabeth, you're up next. Please click on the unmute yourself to make your comment. Thank you.
Thank you. Thank you. This is Dr. Elizabeth Winkleman with the California Psychological Association. CPA is a strong advocate against conversion therapy, and we were instrumental in passing the law that outlawed it for minors. I would also say that APA has a lot of information and position statements regarding the potential harms of conversion therapy. What I wanted to mention is we have not taken a position on this bill, and we're in discussions with the author's office because we do have concerns about unlimited look-back period. Our psychologists are only required to keep their records for 7 years, as you know, or longer for children until they're 25 years old. And the consensus about the harms of conversion therapy was not in place. Like if people can go back and bring lawsuits back from the 1970s or the 1980s, 1990s, you know, indefinitely, we have concerns about the look back period in the bill. So again, CPA is a strong advocate in terms of the harms and protecting people from conversion therapy, but we have concerns about the specific timelines, kind of unlimited timelines of lawsuits allowed from this bill. Thank you.
Karen, you're up next. Please click on unmute yourself to make your comment. Thank you. Karen, if you are speaking, you're still muted. Karen, we still cannot hear you. I'm gonna send you another unmute request. Karen, if you are speaking, you are still muted. Okay,
Can you hear me now?
yes, we can. Please go
I'm
ahead.
sorry for the delay. Okay. We probably all heard about the lawsuits going forth with people that are detransitioning and regretting decisions they made about this surgeries and hormonal treatments, that kind of thing. I would advise that we be very careful about these decisions, just because we are now denying treatment for young people that may be questioning their sexual orientation, but they seem to be pushed into adopting surgery and hormonal treatments prematurely. Their frontal lobes aren't even finished being developed. And so we're asking them to make life-altering permanent decisions that I think is premature for young people. It's a different issue. For adults, they can do whatever they want, but for young people, I think we need to be very careful. Even the APA this week came out expressing a need for caution, even after they had originally been promoting it very, very aggressively. So I'm concerned about these positions that we're adopting decisions and passing laws that later end up going to be, up the judicial chain of command up to the U.S. Supreme Court. We're going to see more and more about this, and the federal government, of course, has taken positions on this. So I
30
think that
seconds.
the Board of Psychology needs to also exercise extreme caution. Thank you.
Joseph, you're next. I'm gonna send you an unmute request. Please click on that to make your comment.
Okay. I'm Dr. Joseph Nicolosi Jr., a California licensed clinical psychologist and amicus brief contributor to the recent Supreme Court case Childs versus Salazar. I represent the interests of many clients who come to me for help regarding early sexual abuse. Bill SB 934 puts a chilling effect on those therapists who work with clients who seek treatment for trauma regarding their unwanted sexual compulsions. When I provide expert testimony to lawmakers before different state senates, I have found that lawmakers agree with the concern that the vague language creates a chilling effect, which would harm therapists doing reputable therapy. Because Dr. Kasuga has communicated that I cannot talk about my specific case, which has now been closed, I would just like to point out that I am being prevented from discussing the most concrete and important real-life example for why the board should not support this bill. I will email my reasons to the board. What I had to experience should be taken very seriously by the board. They should be aware of it, and the board should not support Bill SB 934. It harms clients and therapists. Thank you.
Thank you, Dr. Nicolosi, sorry.
We do not see any other comments. I return the floor back to you.
Thank you, Ms. Moderator. Given the information that we receive from the public, is it possible for board staff to look at this this bill and have an analysis for us? I think that it's good to include a lot more information with regards the positions that that were shared by the public, as well as the interest to protect consumers. So I think that it will be good to have further analysis of the bill, and if that can be shared on our next next board meeting. And I'm interested in either withdrawing the motion or voting it down, and then we can continue to watch this bill.
I'm specifically interested in the issues raised about the liability to practitioners in that look back period, and the comment that characterized it as chilling. I think while my inclination is always to protect consumers, I think we don't protect consumers if we limit treatments or create an environment where some treatments are not available. So I think that a little bit more exploration or more an analysis on that part, the part that what a practitioner would experience, I think would be helpful.
And then it's also good to kind of like take into consideration other public comments that they wanted to submit to the board as part of the analysis, because they're the ones that are have particular examples that may be helpful in the analysis of how this is going to impact the practice in the field. And that way we can have a more informed decision with regards weighing consumer protection and accessibility of different types of therapies for clients that are based on the science.
Dr. Kasuga, this is John Burke, the Executive Officer of the Board of Psychology. Yes, we are currently developing a much more thorough analysis of this bill. When the agenda was constructed and the original materials published, as you can see, this was still a spot bill. So it kind of just indicated that they were intending to make changes, and then a lot more language was amended in, which has required us to do a much deeper dive and look into our enforcement and various statistics and so on. So that will be prepared and ready and presented to the full board at the May meeting. Thank you.
And just wanted to acknowledge that I know that a lot of this is like evolving. The bills are like coming up, and then just wanted to make sure that we have the capacity to have that analysis for the May meeting, because it's in a few weeks.
Yes, thank you.
Okay, thank you so much, Mr. Burke. Yes.
And that was
Dr. Rogers.
actually why I asked the question about what determines whether or not something moves from a watch position to us making a recommendation to the board. I was looking at the information and I realized that there was not a staff analysis. And while I appreciate the spirit of the bill, I figured that we would probably need to have much more information before we could make a recommendation to the board about a position. So I am glad that we will be doing a more in-depth analysis before we arrive at a conclusion. Thank you so much.
Thank you, Dr. Rogers. So at this point, would we be voting, or let's just like have the vote and then
We need to
then vote it down. Yeah, instead of withdrawing the motion. Okay, let's call the vote. Ms. Whitney?
Kasuga?
No.
Cervantes?
No.
Rogers?
No.
Thank you. The motion does not pass.
All right, we'll continue to watch this bill, and we will look forward to the board analysis for a more thorough discussion with the full board. Thank you. For the next agenda items on 5D, they're all going to be watch bills, and we are going to take up the ones that either of the committee members are interested in discussing further. Is there anyone in particular that you want it discussed?
Aren't we going to present all the watch bills since they're new?
Yeah, we can we're gonna discuss them, and what we're gonna do is we'll prioritize the ones that the committee members wanted to discuss, but we can go over the watch bills, and we will have questions at the end. So I'll have Ms. Whitney present it if the committee members are okay with it. Sounds good. Okay, Ms. Whitney, can you present the watch bills?
Sure. So the first one is item 5D1. This is Assembly Bill 1568, which can be found on page 80 of the combined materials. This bill was introduced by Assemblymember Juan Alanis and would require individuals seeking removal from the sex offender registry to provide proof that they completed a certified sex offender treatment program. While the bill does not directly amend the board's statutory and regulatory authority, we are monitoring the bill because the board has enforcement and disciplinary provisions related to sex offense-related conduct. Do you want me to move on to the next one?
Yes, thank you.
5D2 is Assembly Bill 1775, and this is beginning on page 87 of the materials. Assembly Bill 1775 was introduced by Assemblymember Christopher M. Ward and would require boards within the Department of Consumer Affairs to expedite licensure applications from honorably discharged members of the armed forces to include individuals who received a discharge solely based on a specific federal executive order. The bill also modifies reporting requirements related to military licensure data. The board will continue to monitor this bill because it amends business and profession code sections applicable to boards within the Department of Consumer Affairs, including provisions related to expedited licensure for military applicants, which may affect board licensure processes and reporting requirements. The next one is item 5D3, Assembly Bill 2366, beginning on page 92 of the materials. Assembly Bill 2366 was introduced by Assemblymember Cecilia Avila Farias. The bill amends provisions to the Administrative Procedure Act to require state agencies, when proposing regulations, to assess and disclose the cost of living impacts on California residents as part of the economic impact analysis conducted during the rulemaking process. The bill also requires the Legislative Analyst's Office to develop a standardized methodology for evaluating cost of living impacts and to conduct an independent review of certain regulatory analyses. It also requires the Department of Finance to create a regulatory economic burden tracker to analyze the cumulative economic impact of regulations by sector and post this information publicly. Additionally, the bill expands the standards used by the Office of Administrative Law when reviewing regulations to include cost of living impacts and extends the review timeline for major regulations. The bill will continue to monitor, the board will continue to monitor this bill because it modifies the Administrative Procedure Act, which governs the rulemaking process for all state agencies, including boards within the Department of Consumer Affairs. The next bill would be item 5D5, Senate Bill 1146, which the materials can be found beginning on page 113 of the combined packet. Senate Bill 1146 was introduced by Senator Lena Gonzalez. This bill would would require advertisements promoting health-related consumer products or services that use the image, audio, or video of a natural person that is generated or substantially altered using artificial intelligence or other computer technology to include a clear and conspicuous disclosure indicating that the media was generated or altered by AI. The bill also establishes requirements for how disclosures must appear in visual and audio media and authorizes enforcement actions to be brought by the Attorney General or a district attorney in a civil action. The board is monitoring this bill because it pertains to advertising requirements related to health-related products or services, which may intersect with advertising and public communications by healing arts licensees, including psychologists. The bill was last amended last week, and it changes artificial intelligence to digital replicas and synthetic performers. Then Senate Bill, 5D6 is the next item. That's Senate Bill 1159, and that's beginning on page 117 of the materials. Senate Bill 1159 was introduced by Christopher Cabadal. The bill would require that for purposes of several California transparency and governance laws, including the California Public Records Act, Bagley-Keene Open Meeting Act, Ralph M. Brown Act, Administrative Procedure Act, Political Reform Act of 1974, and the California Environmental Quality Act, terms such as person, interested person, participant, and member of the public do not include artificial intelligence systems, autonomous agents, robots, or other non-human entities. The bill also states that these laws are intended to enable participation by natural persons and legally recognized entities, and seeks to prevent automated AI systems from overwhelming governmental processes through mass submissions or automated engagement. The board will continue to monitor this bill because it affects statutes governing public participation, rulemaking processes, public records requests, including the Administrative Procedure Act and Bagley-Keene Open Meeting Act, which applies to boards within the Department of Consumer Affairs. And the last bill is 5D7, Assembly Bill 1598, Quirk-Silva, which is beginning on page 123 of the materials. So existing law requires the Board of Behavioral Sciences to regulate individuals licensed or registered under the Licensed Marriage and Family Therapist Act, the Clinical Social Worker Practice Act, and the Licensed Professional Clinical Counselor Act with violations considered crimes. These acts currently have differing exemptions for certain medical professionals and other behavioral science professionals, attorneys, and certain religious personnel. The bill amends regulation of licensees overseen by the Board of Behavioral Sciences. It expands exemptions so religious officials of any denominations, including imams, who provide faith-based counseling as part of their duties for established faith-based entities, are excluded if criteria are met. It exempts attorneys and physicians who provide counseling within their professional practice from the LMFTA and the LPCCA. The board will continue to monitor this bill because it pertains to psychosocial and psychotherapy. At this time, the bill does not directly impact the board's licensees, but staff will continue to monitor for potential impacts. I'm happy to answer any questions the committee may have on any of these items.
All right. Thank you, Ms. Whitney. Is there any committee questions to any of the watch bills presented? Seeing none, let's turn to public comments.
Hi, this is the moderator. If you would like to make a comment on any of the watch bills, you can click on the raise hand icon at the bottom of your WebEx screen. And if you're on a mobile device, the hand icon may be behind 3 dots, other options. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. I see no comments. I return the floor. Oh, there's one comment.
Okay.
James Willis, you're gonna see an unmute request on your screen. Please click on that to make your comment.
I apologize for being late. I had trouble raising my hand for the previous section. I just want to thank the board members or the committee members for voting down that last recommendation. I think there is a chilling effect to that previous ruling or proposed law, and I really think the issues need to be carefully evaluated before taking a position. Thank you very much for doing that.
Thank you. All right. Ms. Moderator, are there any more public comments?
No, I don't see any raised hands. So the floor is yours. Thank you.
All right. Now we can proceed to agenda item number 6, which is legislative items for future meeting. Is there any legislative items that the committee wants for us to look into in future meetings?
There are several bills, or more than one bill, trying to address conversion therapy, moving through the legislative process. I would like for staff to analyze those, and some of them I think are not within our purview, but they're moving through the process, and as we all know, sometimes language gets amended and then suddenly it isn't within our purview. And I think there's just a lot moving through, and we should be thoughtful in our analysis of that topic this particular year.
Thank you, Dr. Cervantes. Any other bills for future meetings? I think similar to what Dr. Cervantes mentioned, there's always a lot of AI bills. So I appreciate the board staff looking into AI bills that are affecting the practice of psychology. And if there's any more coming in the pipeline, please feel free to put it in front of the board so we can watch and monitor those bills. Okay, let's open it up for public comments on agenda item number 6.
Hi, this is the moderator. If you would like to make a comment, please click on the raise hand icon at the bottom of your WebEx screen. And if you are a public member joining us by call-in, you can press *3 to raise your hand. We are displaying instructions and we'll give you a moment. I see no raised hands. I turn the floor back to you, Chair.
All right. Moving on, we'll take up agenda item number 7, which are status review of regulations in development. I will have Ms. Whitney come back again.
Thank you, Dr. Kasuga. The next item is item 7A through G, regulatory updates, or I'm sorry, status review of regulations in development. The regulatory packages in this item are at different stages of the rulemaking process. The memo provides an update on the progress of each package. The purpose of these rulemaking efforts is to implement new and updated statutory changes and clarify existing requirements. This item is for informational purposes only. However, I do have several updates, and then I would be happy to answer any committee questions. The first update is on 7A, the disciplinary guidelines and uniform standards related to substance abuse licensees. On March 27th, 2026, the regulatory package was approved by agency and sent to the Office of Administrative Law for approval of publishing. The regulatory package was approved for publishing by OAL on April 3rd, and the package was posted on April 10th, and that started the 45-day public comment period. The board posted the package to our website and posted it on our social media pages and sent out a listserv notice to our general subscription list as well as our licensee subscription list. Subsection B, or I'm sorry, 7B, the standards of practice for telehealth services. This package was approved by OAL on March 25th and will become effective July 1, 2026. The board is working on an implementation plan as applicable. Examples of implementation include updates to procedures, advisories, and updating any website changes that are needed. The other item that has an update is 7F, the examination for the TOEFL. The Section 100 package was approved by OAL and became effective on March 30th, 2026. The board is working again on an implementation plan, which includes updates to procedures, advisories, and any website updates. Does the committee have any questions on these updates?
Thank you, Ms. Whitney. I just wanted to acknowledge that some of these regulatory packages have been going on for some time, so it's good to see them moving along and being in the implementation parts now. So it's good to see them moving along. Any other comments from committee members? Seeing none, let's open it up to the public on public comments for agenda item number 7.
Hi, this is a moderator. Oh, do you like to say something in the room, DC? Oh, okay. I'm going to go ahead with the announcement for public comment. If you would like to make a comment, please click on the raised hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. We do have a comment. Bruce, you are up. You are going to be seeing an unmute request on your screen. Please click on that to make your comment. If you are speaking,
hello.
Yeah, now we can hear you. Please go ahead. Thank you.
Good morning. This is Dr. Bruce Reyes. And I have a question regarding the substance abusing licensees. Is there somewhere where I can see, where I can read as to, what are the disciplinary guidelines and standards related to this, to these psychologists, that are abusing substances? Were you able to hear me?
Yes.
Hi. If you go to our website and put in disciplinary guidelines in the search feature, that would pop up all the disciplinary guidelines related content on our webpage.
See no other raised hands. I return the floor back to you, Chair.
All right. Okay, moving along. We'll go to agenda item number 8, update and discussion of the American Psychological Association Model Act. And I believe it's Mr. Burke who's going to talk about this agenda item.
Yes, thank you, Dr. Kasuga. Just let me pull up my notes here. Thank you. So this item is update and discussion on the American Psychological Association Model Act. The APA has updated or is updating the Model Licensing Act, the MLA. The MLA was last updated in 2010. And what the Model Licensing Act does is it provides guidance in multiple areas. None of this has direct impact to any of our laws or regulations, but it's really an informational item. And there are two quite major areas that have been included in the updated 2025 Model Licensing Act. Specifically, there is now a master's level health service psychology licensure, as well as applied psychology title provisions. There's a lot of information about what they suggest for the master's level practitioners in the materials. This wouldn't necessarily be relevant to us in California. The Board of Behavioral Sciences is where the master's level mental health practitioners are housed, and obviously we doctoral level. But so this is an informational item. Just wanted to make the committee and then the board aware of this change the APA has made. But again, it has no direct bearing on us or anything we do. Just wanted to make you aware. Thank you.
Thank you, Mr. Berg. I think one of the things that I wanted to make sure is that the title of licensed psychologist is still protected, and it seems like it still is. So I'm happy that that is still in place.
Yes, and even if this, am I muted? I'm not muted, am I?
You're not, and we can hear you.
Oh, sorry. Thank you. I just wanted to. It is still in the Model Act, and again, even if that title they changed it for whatever reason, that would have no impact on us, because obviously we have the California Psychology Practice Act. But yes, it is good to see that those title provisions are retained in the new version of the APA Model Act.
All right. Any other comments, questions from the committee?
I have a question. Mr. Burke, help me understand. I understand that BBS regulates master's level practitioners, and they have several, I think 5 or 6. But if the APA Model Act is distinguishing a psychologist at the master's level, why do you presume that would fall under the purview of BBS and not under the Board of Psychology that specializes in the profession of psychology and the training of psychologists?
Yes, what I may have misspoke, and in California, the way the existing framework is, the master's level are in the BBS bucket and the PhD level are in ours. Were this new license type to be sunrised in California, I imagine it would come to the Board of Psychology. That's what I was trying to communicate.
Okay. So is there a need then to, kind of look out on the horizon and see if these master's level programs are offered in California? And, the reason I'm suggesting this, and maybe this is me with my academic hat, is psychology as a discipline, as a profession, the training is different than these other practitioners or these other professionals that are licensed by BBS. And I guess I just don't know that they have the experience or expertise or are set up to regulate a psychologist if they presume that we Board of Psychology has that expertise. It's just different. And I don't know if Dr. Kasuga or Dr. Rogers want to chime in since they're the practitioners. I'm just the academic. My question is really if we should be looking ahead and planning for or preparing for a possible adding this possible registration at some point in the future, and what all that would entail.
I I think that's a good question, but I don't want to get ahead of ourselves in terms of like an additional registration for master's level psychologist. But I will have Dr. Rogers comment on it, or the board staff.
Hi, Dr. Cervantes. As I am reading through it and listening to Mr. Burke and his mentioning of the California Psychology Practice Act, my understanding is that this is something that we should be aware of, and if there are any changes that would need to be made, one, how far out into the future would we be looking? And two, if this is coming from the APA, would we need to make any changes to the California Psychology Practice Act? Because if that's what we already have codified here, does this have much bearing on that?
I think what we probably need is an analysis to know if these programs are coming online here in California. And then, presumably there would be some population who would need some kind of registration or something at that point. But if we don't even have these programs in California, then maybe that's the non-issue.
Go
ahead, Mr. Burke.
Sorry, it's John Burke, Board of Executive Officer of the Board of Psychology. So would you like, I think there are some jurisdictions where there are master's level psychologists. I don't know that off the top of my head. And I think that's certainly the case in Canada. So we can look into what that looks like. And then obviously we have the proposed requirements here. But again, this is just it's sort of a guideline. And there hasn't been a push. We've never been contacted by anyone about, oh, we need to start having a new master's level psychology license. So, but we can certainly look into what it's like, whether there are schools here that offer it. I think that there certainly are schools in California that offer the qualifying degree that they lay out in the Model Act.
So, in my understanding, Dr. Cervantes, if someone, let's say, has a master's in counseling psychology, they won't be eligible to get licensed as a psychologist in California under the Board of Psychology because a doctorate is required. Their avenue would be then to either pursue a license with BBS in terms of an MFT license or something similar to that. Is your concern what would happen to those individuals, and about like access to
my specific concern
psychological
is that I don't know if BBS has expertise in the profession of psychology the way that this board does. And so if there are individuals trained in psychology at the master's level, and this is like an emerging area, are we prepared to capture that? Now, I'm not advocating we add a registration because I don't know enough about this, but I think that BBS has several they license in several fields. I just don't know if there's expertise to do that. I understand that where we are segregated, them at the master's level and us at the doctoral level, but we are also specific to the profession of psychology. I don't know that they necessarily have that expertise. A social worker, even at the doctoral level, is not trained the same as a psychologist, right?
I hear you, Dr. Cervantes. I think my understanding is with regards the California Practice Act is that in California we want someone who has at least a doctorate level of education, so someone who is to practice psychology. So if someone, let's say, has a master's degree, they can get licensed in both BBS and in with the Board of Psychology, but they have to meet that extra bar because we don't, even though in the APA Model Act they have like a master's level psychology practice. In California, we require more. And so like unless they meet that bar, then they won't be able to apply for a psychology license in California as it stands now. So I guess my question is like, are you interested in looking at how other jurisdictions are that have master's level practitioners handle their licensure, or I'm trying to see like what directive we can provide a board staff in terms of the changes with the APA Model Act.
I think both are appropriate. How other jurisdictions do it, and if there are training programs in California that are similarly situated, and then I think the board can make a decision if there's some other change that needs to happen. I guess I'm just open to that possibility and not just assume that BBS has the expertise to deal with this particular profession, psychology.
I think that in terms of, I'll let you answer, Mr. Burke. Sorry.
Sorry, I just wanted to say, yeah, BBS obviously currently doesn't have because they don't license psychologists, and there's nothing coming in that there's no law or regulation that would currently have California Board of Behavioral Sciences having anything to do with psychologists. My reason for bringing up the Board of Behavioral Sciences was simply just because the APA Model Act is now envisioning a potential license type for a master's level practitioner. And in California, the way it's been hitherto is master's level are under BBS, and we have psychologists who require a PhD. That's all I meant, and there's no movement or legislation or anything like that which would sunrise this new license category and then place them anywhere, but to us or to BBS.
Understood. I just want to, look ahead and not just cede that authority of this and expertise of this particular board.
I just wanted to add, sorry, go on.
The other thing I want to say is that there are similar trends in other fields for master's level practice. And so it's interesting. I think I think there's a lot of things happening just kind of in society that, doctoral level training takes a long time, it's costly, just different things. And so I think it's wise to just be aware and what all of those pieces could look like in the future.
Thank you, Dr. Cervantes. And I also just wanted to point out that as a licensee as well, that I think that the quality that the doctorate level as a minimum requirement for Californians has been a really good bar, because we want to make sure that we're maintaining the quality of psychological services in the state of California. And I truly believe in that. The current minimum requirements that we have is appropriate for the practice of psychology in the field for Californians. But I'm open to looking at other jurisdictions, and as it relates to changes in the society, like what you're saying, Dr. Cervantes. I think for now, I think it's just good to know that the APA has provided both this changes with regards master's level, but also the applied psychology guidelines, which I think there's been a lot of applied psychology practice, including the practice of sports psychology or organizational psychology. And it's good that APA has presented certain like licensing models for those, and it's helpful for the growing and expanding field of psychology. So I think it's good to just like like keep like what you're saying, Dr. Cervantes, keep our eyes to what is happening in the future, and be in the lookout for when we will need to act or prepare for any changes that we need to take on in California. I hope that, like partially answers your question, or
Yeah. I mean, just I think this board and the staff have an expertise in the profession of psychology. And so I don't want to presume that that expertise exists anywhere else in the BCA.
Definitely. Thank you. So now let's open it up to public comments on agenda item number 8.
This is the moderator. We do have public comments. Elizabeth, you're first. You're going to see an unmute request. Please click on that to make your comment.
This is Dr. Elizabeth Winkleman again from the California Psychological Association. I want to thank you for this discussion. As you've said, this is a model act. It's a suggested template from the APA. So it would only, any of its provisions would only apply if there's legislative change to California licensing law. ASPPB and APA, I think, do have data on which states have licensing at the master's level. There are a few that have independent licensure for psychologists or with another title. Some are supervised. So that data is available. I wanted to agree with Dr. Cervantes that if there is any master's level psychologist, we already have licensed educational psychologists, but as foreseen by this APA Model Act, I do think that the Board of Psychology, not the Behavioral Sciences, would probably be the best place, and that's how other states have handled master's level psychology, is they've gone under the Board of Psychology, not under a separate board. And then I also wanted to mention that this is an extremely controversial topic, the master's level within the field of psychology. APA has been discussing this for at least a decade very seriously, and it took a long time for them to come up with a model act. And within the profession, there are many people strongly opposed to it. Some are very supportive of it in terms of, Oh, I just have a few seconds, so I'll wind it up. Anyway, just to note that this is a topic with a long history and a lot of differing viewpoints within the field. Thank you.
Thank you, Dr. Winkleman.
Mary Frank, you are up next. You're going to see an unmute request. Please click on that to make your comment. Thank you.
Good morning. Can you hear me?
Yes, we can. Please go ahead.
Okay. I just wanted to say that in terms of in the future, like with our pocket licenses, our wallet licenses, it just has psychologists. And I was wondering after our name if we could have like PhD or PsyD or what our title is, since now that, that maybe, I would just like to see that, because I called several years ago the board and I was told that it would cost so much to put that behind our name. And I was wondering why can't that happen? And now with these controversies of whether it's going to be a master's level psychologist or what kind of level psychologist, why can't that just happen? And I was wondering if that, and I know that can't be an agenda item, but it's something that could happen, because when I was in France talking about psychologists, and I proudly showed my little card, and they said, "But do you have a PhD?" And I didn't cry because it was kind of funny and I was at the Eiffel Tower, but it was like, okay, what does this really show? And that's all I really have to say. And thank you for your time.
Thank you, Dr. Frank.
Dr. Davis, David, you're up next. Please click on the unmute yourself to make your comment. Thank you.
Yes, I would raise two potential concerns. One is the continuing impact on a reduction in market share for PhD level psychology. Second, were this to occur. Secondly, the increasing confusion among consumers as to what makes us unique and different over BPS practitioners. Thank you.
Thank you, Dr. David.
James, you're up next. Please click on the unmute yourself to make your comment. Thank you.
Thank you very much. This is Dr. Willis. I'm one of those people who started out with a master's degree in psychology, then went to the MFCC for licensure back in the 80s, then got a PhD and struggled through the licensing process and became a psychologist in 2002. I see a straight pathway. I found the Board of Behavior Examiners folks to be quite cognizant of transcripts and understanding the various types of internships and training. So I don't think they would have that great of a problem, but I would prefer that the board develop some planning so that in the event that the legislature decides to do this, and it does seem that the legislature has the lead, that the board would be prepared to fold master's level psychologists with an amended title, so that it didn't say just clinical psychologist, but perhaps associated psychologist or something like that. I would prefer that this be managed by the Board of Psychology. And I would encourage you to have staff develop some planning in order to do that, should it happen, because again, as I said, it looks to me like the legislature leads on these things. Thank you very much.
Mary Frank, you're up again next. Please click on the unmute yourself to make your comment. Thank you.
I just wanted to make sure that I was understood about what I had said about the pocket license, and if that actually could be considered. That's all. Because I heard people, I was just, I thought I was just kind of looked at like I hadn't been heard, and I just want to make sure that it was. Thank you. Bye-bye.
Next up, we have Mr. Evans. Evans, you're going to be Gwendolyn. I'm sorry if I mispronounced your name. Please click on
Can you hear me now?
Oh, yeah. You hear you. Please go ahead.
I've been in practice in San Francisco for 34 years, also a neuropsychologist as well as a UCLA clinical psychologist. And the number of years when I've been interviewing clients over the phone, what are they looking for? They don't know, the general public really doesn't know the difference when a person says, oh, I saw a therapist, and I'll ask them, and what was the license of that therapist? And then they'll hunt their minds and they'll say, oh, she was an MFT. It doesn't make a difference to the public, but it does to us. And at the level of insurance companies, there's not a difference between a PhD doing 90834 and a master's level person doing the same. The few times that I get called on as specifically as a PhD, especially from insurance-based clients, is if they know they're in a lawsuit and somebody's told them get a PhD, or they want to get paperwork done to get a family medical leave, something that where they don't want it to be as challenged as you were not seen by somebody who really understood the higher level disorders that they come to me for. So I see our market share declining, and I was at an event last weekend, and the person is MFT, and I've known her, and she's also very successful.
30 seconds.
She tells people that she is a therapist, and they immediately assume, because of her success, that she must be a psychologist. So that's my bias, that I'd like to keep the difference between the two. Because I also hold 3 master's degrees. One of them is in psychology. Bye.
Thank you, Dr. Evans.
Andrea, you're up next. Please click on the unmute yourself request to make your comment. Thank you.
Thank you. I wanted to echo Dr. Winkleman's comment about how controversial this is, and I hear a lot of the concerns in those attending the committee today about the loss of market share for psychologists. But I also want to highlight what Dr. Cervantes said about, unfortunately, the BBS is the de facto licensor for master's level students in clinical psychology. Almost I train many students, and nowadays most come with a master's degree in clinical psychology, and then they go to the Board of Behavioral Sciences to get a license, which has totally confused the public, I think, and related to the just prior comment. I think there needs to be a larger look at this issue of how the BBS actually exists and licenses people who've studied psychology. Versus say a master's in marriage and family therapy, which would make more sense to become a licensed marriage and family therapist, to clarify these distinctions in preparation and who gets to say, what a psychologist is. We should retain that at the Board of Psychology level. And I think the confusion is a huge problem. I'm concerned about it as well.
Thank you, Dr. Davis.
We have Dr. O'Neill next. You're going to be seeing a request to unmute yourself. Please click on that to make your comment.
I just want to be sure I got this exactly right. California is now considering adopting or following the Model Act where it did not before. Is that right, or have I got it mixed up?
No, this is an information only item from the Model Act.
So we are still not adopting or following or intending to adopt or follow the Model Act. I can't help but wonder why we are spending time on it. I don't mean this pejoratively. I'm very interested, but I don't understand why we're doing it. Thank you.
Thank you, Dr. O'Neill.
Dr. Bruce, you're up next. You're going to be seeing an unmute request. Please click on that to make your comment.
Thank you very much. This is Dr. Bruce Reyes. In my approximately 35 years in the field of psychology, I too began as an MFT and then segued over to becoming, over the years, a clinical psychologist. And I worked in a UCLA medical clinic for 25 years. And then I also worked for the Department of Corrections for 10 years. And in all this time, I found that public doesn't have a clue what the difference is between a psychiatrist, a psychologist, a therapist, a psychotherapist, a counselor. They're usually, unaware of the differences and how that may affect them. I've seen so many MFTs with, PhD after their name. Master's level clinicians with credentialed as PhDs, and that's so confusing. Also see this as a turf war.
30 seconds.
To get into correctional facilities. MFTs are currently not allowed to work in correctional facilities. Social workers are and psychologists are. And so if an MFT were to obtain a psychologist license, they'd be into the prison system, state psychiatric hospitals, and
I see no other comments. Please, I return the floor back to you, Chair.
All right. Thank you. That's like a really rich discussion over there. And again, this is an information item as it is. And do you have any other comments, Dr. Cervantes, Dr. Rogers?
I just have one question about whether or not this agenda item will also be brought to the board meeting in May, just so we can have a broader discussion.
Yes, it'll be in the it'll be in the report that this committee makes to the full board. It'll be on there.
Fantastic. Thank you, Mr. Burke.
Thank you.
Yeah, thank you. I think that will be where this can be discussed further, because part of it is really related to a different committee altogether, which is, licensing. And in terms of our board, it's mostly just if there's any legislative changes in California that comes about from this. So if that were to happen, then we'll have to respond. And that's what I think Dr. Cervantes is thinking about in the future, is if that were to be adopted by the California legislators, then we will have to make sure that it is housed accordingly to the board that has expertise in it. But it's definitely something that is worthy of further discussion. And I appreciate some of the information that we got in terms of jurisdictions. I guess if we can have that available, Mr. Burke, the ASPPB information or APA information about jurisdictions that have master's level, and just, even just to see how they are naming the individuals that are practicing with a master's versus doctorate. I think I'm curious to see those differentiations.
Yes, we will gather that information for you and present it at the hopefully the May meeting. Should be enough time to gather it. Thank you.
All right. Any other comments on agenda item number 8 before we move on? Seeing none, we'll move on to agenda item number 9, which is recommendations for agenda items for future committee and board meetings. Note again that the committee may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. So as I always bring it up, but I'm really happy for Dr. Rogers to start us off with a mindfulness activity for a future committee meeting and board meeting. I think I'm the official suggester of the mindfulness activity. I think it's really good way to start any meeting.
Happy
Any
to
other
continue to help out.
Thank you. Any other suggestions for future agenda items?
Yes, I have two.
Mm-hmm.
You ready, Mr. Burke, to take notes?
I am Dr. Cervantes. Thank you.
So one issue that was raised at the start of the meeting that I am not entirely familiar with is the CDCR bringing out-of-state providers to serve their population. This concerns me very much because the public may not know, but we see a number of enforcement cases with that come through that are in these settings. And so I'm concerned about our jurisdiction in the context of license of people who may have licenses from other jurisdictions practicing in these settings in California. I just don't know enough about it, but I think it merits more careful review by this board and to ensure that we are taking appropriate action to protect consumers.
Do we have the bill number for that?
It's not. It's am I muted again? Oh, okay. I'm jumping between tabs, so apologies for that. This is not a bill. It is something that CDCR, they're trying to address the problem of mental health practitioners within serving within CDR's system, and it is one of the ideas that was proposed, and so it's not a bill yet. Nothing formal has come. It's just a suggestion that has been made. The legislature can do what they want with that. I obviously can't speak for the board, but upon analyzing any bill which essentially allowed any out-of-state licensee to just come and practice within the CDCR system without any licensing oversight or registration with us, that would be something in our analysis we would recommend and oppose to, simply because of the potential lack of oversight, harm to California consumers. The inmates are California consumers of psychological services, as well as the precedent, which, there are mental health needs all over the state for many reasons, and allowing anyone to come in. And the language is vague. It doesn't specifically mean it would also apply to psychiatrists and other license types as well. So yeah, it isn't a bill, but yes, we'll be monitoring it. Thank you.
And is CDCR under receivership? Is that the?
I don't know. I don't know.
So there might be, it might not, my extreme concern about this is that it may not come through a bill, but it might come through some other administrative action.
Like a directive?
Yes, especially if they're under receivership. And I don't want to be passive about it. I think that there is enough reason for concern. Even, even if there is not enough workforce of licensed psychologists, there are other, like we talked earlier, there are other California licensed therapists at the master's level or in other or retirees that could come back. Like, there are other ways to deal with a workforce issue that does not undermine our regulatory authority. I just want to really emphasize that. So I think that it just merits more closer scrutiny and that we're not passive about it. The second issue that I have, Mr. Burke, we briefly discussed this last year, and it was on the emergence of AI in the field of psychology, the field of psychology practice. We had no less than 3 bills that we analyzed today: SB 1146, SB 903, AB 2575 dealing with practice, and then SB 1159 dealing with our work as a board. I bring this up because I think we need a session, and maybe this is like at the end of the year after the legislative process kind of dies down, so that we can, as a board, analyze the whole landscape of how AI is entering the field and identify gaps or anything that might be emerging that might need further scrutiny, so that we can be more proactive instead of just responding to things that are moving through the legislature, but that we are actually on our front foot, protecting California consumers. There is a lot of things, and it's not just protecting consumers of California, but also giving guidance to our licensees about what is appropriate use of AI in the field, or in practice, I should say. I think both are important, and I think that it's important that this board take a leadership position analyzing the whole of AI and how it's coming into the space. Thank you. Those are my two for you, Mr. Burke. I know they were loaded.
Thank you, Dr. Cervantes.
All right. Any other recommendations? I appreciate Dr. Cervantes' recommendations. I share your concern as well. All right. Let's have public comment on agenda item number 9, recommendations for agenda items for future committee or board meetings.
Hi, this is the moderator. We do have 2 comments. James, you're going to be receiving an unmute request. Please click on that to make your comment.
Hello, my name is James Scott. I'm a chief psychologist with CDCR. I just wanted to clarify that the out-of-state recommendation came from the Legislative Analyst's Office in a report titled Addressing Chronic Vacancies in Prison Mental Health Care, dated February 23rd, 2026. So not necessarily something CDCR is recommending, it was the Legislative Analyst's Office. That's all.
Thank you. I just wanted to remind the public that this is recommendations and no discussion, but I appreciate that clarification. Thank you.
Next up, we have Dr. Bruce Reyes. You're up. You'll be seeing a request to unmute yourself. Please click on that to make your comment.
Thank you very much for your participation today. This has been very interesting. At the very beginning, there was an announcement about attaining CPD credits, and there was I didn't have my closed captioning on at the time, and I wasn't able to get the email address, and I was wondering if I could please have that repeated prior to adjourning today.
Definitely. So that will be the next item. Right now, we're still getting recommendations for future board meetings. Are there any other comments for agenda item number 9?
Yes, we do have Timothy O'Brien. Timothy, you're going to be up next.
Thank you.
Please click on unmute yourself to make your comment. Thank you.
Hello. I just wanted to support Dr. Cervantes's comments about AI and the focus on that. And during the discussion of, I think it was SB 903, there was a specific question from one of the committee members about whether assessment was covered. And so I think you're really highlighting assessment as well. I think it's particularly vulnerable to the abuse of AI, given that it requires some specialized training. Like the ABPP and Houston Conference, requires 2-year fellowships in neuropsychology, for example. And so I think, it would be really tempting for someone who doesn't have that sort of training to just pop test scores into a AI and say, okay, generate a neuropsych report, or for corporations to develop computerized testing and then generate a report that without that specialized training. So I think that really has to focus on assessment when it comes to AI, and to ensure the quality of care for the consumers of California. Thank you.
Thank you, Dr. O'Brien.
We have the last comment from Kim Cornish. You're going to be seeing an unmute request. Please click on that to make your comment. Kim, if you are speaking, we cannot hear you. You're still muted. Please click on the unmute request on your screen, the prompt, to make your comment.
Can you hear me now?
Yes, we can.
Good. I work for the Department of Corrections. I'm actually the specialty reviewer for our credentialing verifications unit. In September, the federal court did take over mental health. It is under receivership, number one. And number two, there are options now that have to do with waivered psychologists and waivered unlicensed folks from out of state to be able to work in our licensed beds, that they still fall under our penal code requirement of 4 years to become licensed. I do believe that there is some, well, I know there is, they have to become licensed, so they'll have to go to the appropriate board. And 3, we do hire BBS licensed and unlicensed professional counselors, marriage and family therapists, and social workers. So there's a lot at work with that. And so I am more than happy to work with, provide information to Mr. anyone with all the things that I know since I do this specialized area.
Thank you, Dr. Cornish.
I see no. Oh, there is another one other comment. Dr. Tawhid, you're going to be seeing an unmute request. Please click on that to make your comment.
Yes, hi, it's Dr. Tweedy. I want to reiterate the point about the retired annuitants in the Department of Correction. I know it is possible because I have worked as one, but I was only able to do so by pursuing different institutions and speaking to the chief psychologists or chiefs of mental health to find a position. There is no easy portal to which a person who is a retired annuitant can apply. And I find it kind of amazing given that contracting agencies are paying psychologists $165 an hour. And that doesn't even account for what they take for the contracts because they also have to pay themselves. Whereas a retired annuitant is only paid exactly what the rate would be minus the benefits, which is less than half of that, roughly $78 an hour. I just think it's a terrible waste. Thank you.
Thank you, Dr. Tweedy.
We do have no other comments. I turn the floor back to you, Chair.
All right, thank you, Ms. Moderator. Now I would ask Mr. Pohl to talk about CPD credits for today's committee meeting before we adjourn.
Yes, thank you. So thank you for attending the Legislative and Regulatory Affairs Committee meeting. For attending the full duration of today's meeting, 6 hours under CPD category number 1, attendance at a California Board of Psychology meeting can be credited. The 6 hours will also apply to law and ethics. For your CPD records, please notate today's date as April 24th, 2026, the name of today's meeting, which is Legislative and Regulatory Affairs Committee meeting, and 6 hours for your records. Again, please maintain this record as certificates of attendance will not be provided by the board. For attendees who joined by phone and called the U.S. toll phone number, please send an email to bopce@dca.ca.gov. Again, the email address is bopce, as in Board of Psychology Continuing Education, @dca.ca.gov. Please provide your name, license number, and the phone number of the phone you called in from. Attendees who signed in using a computer or mobile device from the WebEx link directly, your attendance is automatically documented and no further information is necessary. Thank you.
All right. That concludes today's committee meeting. I appreciate all the efforts of board staff as well as my committee fellow committee members, Dr. Rogers and Dr. Cervantes, and all our public that are that participated and with us today. Thank you so much and have a good weekend.
Thank you, everyone.
Thank you.